The most spectacular sight in the sprawling campus of the O.P. Jindal Global University is undoubtedly that of the Indian tricolour. This gigantic and glorious Indian flag is visible even from miles away. A piece of cloth called the national flag stands for the whole nation, its honour and glory. When it goes up the flag mast, the heart of a true citizen is filled with pride. However, it was not until the 23rd of January 2004 that the citizens were free to hoist the Indian tricolour. Not until the Supreme Court delivered its landmark judgment in the Union of India versus Naveen Jindal and granted Indian citizens the fundamental right to fly the national flag. The journey to this celebrated decision of the Supreme Court is a long, hard and principled fight by Mr. Naveen Jindal. Mr. Jindal, the then joint managing director of Jindal Strips Limited, started flying the national flag at his office premises in Madhya Pradesh. To his rude shock, he was told by certain government officials that the flying of the national flag was not permitted under the law, and so Mr. Jindal was liable to be prosecuted for flying the national flag in his premises. Aggrieved, Mr. Jindal, under Article 226 of the Constitution, challenged this restriction on the flying of the national flag by private citizens and sought to have the same quashed for being illegal. He also asserted that the prohibition imposed upon him from flying the national flag in a respectful manner was an infringement of his fundamental right guaranteed under Article 19(1)(a) of the Constitution. The petitioner, Mr. Jindal, maintained that the prohibition was violative of his fundamental right to freedom of speech and expression under Article 19(1)(a). However, the petitioner's act of flying the flag was contended by the respondents to be violative of the Flag Code, which contains instructions issued by the government to ensure that the correct usage regarding the display of the national flag is understood. It was submitted that for all practical purposes, the Flag Code is the law on the subject and that it was the fundamental duty of the citizens to follow these instructions. It was also argued that by trying to hoist the national flag at his factory premises, which was a commercial place, it was apparent that the petitioner had the motive to take commercial advantage of such hoisting. Rejecting the submissions of the respondents, the Delhi High Court held that the Flag Code contained merely the executive instructions of the Government of India and hence did not qualify as a law within the meaning of Article 13. Hence, it could not be an instrument to restrict the right under Article 19(1)(a). The right is restricted, rather, by the Names and Emblems Act of 1950 and the Prevention of Insults to National Honour Act of 1971. Further, even in the case of an alleged violation, the same was to be decided by the court and not by the government officials. The court thus allowed Mr. Jindal's petition, holding that the restrictions under the Flag Code could not be enforced unless the flag was flown in contravention of the law. The Union of India, preferring an appeal, moved the Supreme Court through a special leave petition for the determination of the question as to whether or not the right to fly the national flag by an Indian citizen was a fundamental right within the meaning of Article 19(1)(a). Answering the question in the affirmative and dismissing the appeal, the Supreme Court on the 23rd of January 2004 finally settled the decade-long matter ardently pursued by Mr. Jindal. It thereby enshrined the right to fly the national flag freely with respect and dignity as a fundamental right.